I'd like to welcome everyone to the first of a four-part series on the collaborative practice of law. My name is Eileen Harris. I'm the Executive Director of the Alabama Center for Dispute Resolution, and the center is pleased to co-sponsor this webinar along with the Dispute Resolution section of the Alabama State Bar, the Birmingham Bar Dispute Resolution section, and the Birmingham Collaborative Law Alliance, a series of free webinars throughout the year. As I indicated, this is the first of a four-part series on the collaborative practice of law. Before I introduce today's speakers, I would like to cover just a few housekeeping rules. We've got attendees from all over the state joining us today, and so we're going to ask if you would please mute your phones to help ensure we can all hear the presentation without any interruption or distractions. We ask that you please, if you're listening by phone, not to put your phone on hold. And this will help to ensure that we've got a great program. We will take questions throughout the program. You can use the chat box to type in your question that will be monitored by our panelists. Or if you want to, you can save your question to the end of the program and enter it in the chat box. If you're seeking continuing legal education credit with the Alabama State Bar, I'd appreciate you completing the evaluation that was sent yesterday or the day before yesterday with information along with the slides that you'll see here today. During the webinar, I will provide you with a code to enter into the survey, and this will help ensure that the requirements for the Alabama State Bar attendance are complied with. And last but not least, today's webinar is being recorded. I will also put in the chat box, for those of you who may have missed the link to the program evaluation, the link to SurveyMonkey to allow you to complete that. Again, if you're just now joining us, we are just now beginning our program. I'm going to ask that you please mute your phones so that we can have a great program. And at this point, I'd like to turn the program over to our excellent panel for the presentation. I mean, you can ask for a better group of folks who understand and practice the collaborative practice of law.
Thank you, Eileen. My name is Brian Turner. I am an attorney in the Birmingham area, also a mediator, and we'll be touching a little bit later on how those interact with collaborative law. I've been collaboratively trained for several years and been including and incorporating collaborative practice actively into my domestic relations based practice, and look forward to speaking with you and hopefully answering some questions for y'all today.
Hey everyone, I'm Virginia Miller. I'm also an attorney here in Birmingham, Alabama. I have been collaboratively trained for about, I'd say 10 years at this point, and have been actively seeking additional training and trying to learn more and more as I go along. I basically mimic probably everything that Brian said about collaborative practice and trying to implement, even if it's a sort of a mainline divorce case or any type of case, really, I try to implement the tools that I've learned in collaborative, and it seems to help. And I would just like to personally say, I think that those of us that are collaboratively trained have sort of changed maybe the way people even litigate in at least the Jefferson County metro area. So I'm really glad to be here with everybody today and appreciate everybody listening. And also thank you to Eileen for always supporting and being a champion for us. So thank you.
Yeah, thanks, Eileen. My name is Frances Nolan, and my firm is Nolan Byers. I'm in Birmingham, and my practice is dedicated exclusively to domestic relations. I have been collaboratively trained for, I don't know, 10, 12 years. Brian and Virginia and I have all worked in Alabama to make collaborative available to clients and to train professionals. And it is with great pleasure that we are asked and accept the invitation to talk about our favorite subject. I do believe we have changed the face of domestic relations practice in our jurisdiction. And for that, we're very proud, even though we have not made collaborators out of everyone. I believe that I am charged with, I can't see the slides, Brian, so I'm going to trust that you are on the right one. Are you ready for me? Yeah, so the first thing we want to talk about is just to give you a basic thumbnail sketch of what is collaborative. I don't know how many of you have ever heard of it or are familiar with it. We just want to make sure that you understand the basic principles of what collaborative is. I think one misconception about collaborative is that it's just sort of like a mindset, you know. Well, that's true. It is a mindset, but it is actually a very formal process that requires some very formal steps to be officially a collaborative process. It is voluntary, consensual, and non-adversarial, which I think is what makes it most challenging for those practitioners who have spent their whole lives being adversarial. The process generally employs a team of professionals working together to assist the parties in crafting a settlement. The professionals are lawyers, mental health, and financial, and when necessary, a child specialist. The goal of the process, of course, is to reach a resolution. But the real cornerstone is the participation agreement, without which you are not collaborating. The participation agreement is what protects us as lawyers. Brian's going to talk about informed consent, and I guess the sort of flip side of that is, for us as lawyers, we need to make sure we're doing something that is ethical. And we are unbundling our services and providing a limited scope representation when we collaborate. And both our engagement agreements and the participation agreements reflect that. But most importantly, the participation agreement reflects the fact that if the process does not result in a settlement, the parties needing then to litigate their case have to hire new lawyers to represent them in that matter. The goal in creating collaborative in that way is to make sure that everybody engaged in the process has the same skin in the game. Their focus is the same thing as the parties. We're here to help you achieve a mutually acceptable outcome. And nobody, by virtue of that, is hanging a hammer over anybody's head, screaming about what's going to happen in a courtroom or what a judge is going to do. That changes the face of negotiation and collaboration, and it allows the process to unfold more directed toward the interests and goals of the parties and less focused on the bargaining of positions and legal arguments. How does it work? Well, if you have been involved in business in your life, then you have probably engaged in meetings that were agenda driven and that were memorialized by minutes. And if you have done that, then you would be familiar with the way that collaborative unfolds. Rather than trying to cram a settlement negotiation and agreement into a giant long, hours-long day, we divide it into bite-sized meetings where we address specific issues and where we have present with us those members of the team who are necessary to help the parties deal with whatever it is they're talking about. One of the major differences is we want the parties eyeball to eyeball. We want them looking across the table at one another. We want them speaking for themselves. We do not want to be their mouthpiece. Our goal is to coach and assist them in learning how to speak for themselves. And so the process is very much designed to facilitate the parties' direct interaction with one another. As you can imagine, that requires some ground rules. So the participation agreement establishes a great number of ground rules that the parties have to be bound by in the process of having a collaborative divorce. The participation agreement addresses everything from full disclosure requirements to maintaining financial status quo to the confidential relationship that you have with your lawyer and how it differs in the process to rules for communication. The rules for communication is a 2-page long portion of the participation agreement. And we do go over that in detail with people, and we do hold their feet to the fire about it. The parties are agreeing to use good faith in their negotiations, and they are agreeing to be respectful and to be interest and goal focused instead of argument and position focused. The lawyers, of course, I'm trying to follow along on the sheet. And I'm not sure I'm following it very well. Okay, each party must be represented by a lawyer whose representation terminates. I think we've gone over that. You might, I don't know, do we have a specific part where we talk about the role of the mental health professional? I guess we go into more detail about that in our next presentation, but the mental health professionals are not pathologizing. They're not therapists. They're coaches. They're trying to help the parties communicate effectively with one another. The neutral is there to be the marshal of financial information and to present a neutral front about what the information says and means. So the process unfolds in this series of choreographed meetings that are agenda driven and memorialized by minutes. And it may unfold in any number of ways. There may be parallel processes going on. At one time, the parties may be meeting with the financial advisor and their lawyers to talk about financial issues. And at the same time, or at similar times in the process, they may be meeting with the coach or coaches to begin to work on their parenting plan. So I think that covers pretty much a general overview of what the process is and how it works. Brian, I'm going to turn it over to you to talk about informed consent.
Sure. I did want to add a couple things with that too on how it works.
Please.
Sure. One of the very interesting parts and for me in working collaboratively is having these other professionals as part of the team. And when we talk about the coaches, they are trained mental health professionals, usually psychologists, but they are really there to help us figure out how to address the issues that the parties are facing, the communication problems they're having. And I often tell the clients they coach us as the lawyers as much as they're coaching them. They're helping us see how we can be more effective in these meetings, in generating communication between the parties. And having a neutral financial professional, whether it be a CPA, financial planner, whomever who fits the specific case. And that's the other beauty of collaborative. These are the parts that fit this case for these parties. Having that person be the one that receives all the financial information and make sure we're all singing off the same sheet of music. It allows for a lot more creative problem solving than if we're all just throwing documents at one another and hoping that we all understand what a particular financial document may or may not say. When we have the professional there, can explain and make sure everybody clearly understands what's going on. But as Francis was saying, informed consent is the key starting out, and the need for it cannot be overstated, and the impact cannot be understated. And we say that because what clients are doing when they engage us as attorneys to represent them collaboratively is they are entering into a limited scope representation that is provided for under the Alabama Rules of Professional Conduct. It's incorporated into the Collaborative Law Act. And they need to understand that we are serving as settlement counsel. We are not here to represent them in court. They need to understand that by hiring us and signing the participation agreement, they are waiving certain discovery tools that would be available to them through court. We're not going to be issuing subpoenas. We're not going to be taking depositions. We're not going to be, sending interrogatories. That everybody is agreeing that they will exchange information voluntarily and be transparent in the process. That they understand that if they aren't, the process can be terminated, and that while attorney-client privilege remains fully intact, and that's a question that we get frequently is how do you have attorney-client privilege with all this transparency? If your client refuses and says, no, I'm not going to disclose this bank account that I have at Compass Bank that my spouse does not know about, and today primarily talking from the standpoint of a divorce or domestic relations, although collaborative can apply in many, many other fields, that the lawyer may pull the plug and say, hey, if you're not going to follow what you've consented to, what you've signed off on, we're pulling the plug and you're starting back over at square one, not only with new litigation counsel, but without any of the work product generated in the collaborative process. So the parties have to truly understand what it is that they are signing up for, and they're not going into it blindly. I know that a very large part of my consultation with a client who expresses an interest in collaboration is to walk through the differences between what collaboration is versus litigation versus straight attorney to attorney or party to party negotiation versus mediation, so that they realize what they're signing up for. And then when they're in the middle of it, they can't turn around and come back and say, well, you did not tell me that you would not be sending subpoenas to the bank or to his employer or her friends or whatever. That's the quickest way for a collaboration to blow up, is if the clients don't understand what they're getting into. So like I said, I cannot overstate the importance of the participation agreement, which lays all of this out and is required as a part of a collaboration to qualify under the Collaborative Law Act. And even the notices that we file when we've kind of going into the mechanics a little bit, nothing is filed with the court until there's a final agreement. Everybody's agreeing with this participation agreement and are consenting to sitting at the negotiation table until an agreement is reached. Once a final agreement is reached, the attorneys are then preparing the paperwork to file with the court. But even our notices of appearance are under the limited scope representation provisions of the rules of professional conduct, so that when we appear, we are appearing as limited scope counsel specifically for walking the documents through to finalize what in essence becomes an uncontested divorce. With that, I will pass the ball to Virginia to talk a little bit about how this differs from litigation.
Hey, everyone, and thank you again for allowing me to speak on this subject. How does it differ? Well, it differs a whole lot. There's obviously there's no judge involved. There's no jury. And obviously, I'm sorry, I'm skipping around. The first bullet point is it uses a structured interest-based negotiation process. And so I think Brian and Francis both touched on that when you heard Francis talk about being in board meetings and taking minutes and having agendas. So it's very structured that we are going to have a certain meeting on a certain day, and this is what we are going to discuss. And this is going to be how long it takes. Or this is going to be the set time frame for that. So everybody knows, the clients know up front, the parties know, we've talked about it, we've briefed our clients beforehand, and then we have a debrief after the meetings normally. And it is very much like a board meeting situation. And everybody acts as their highest and best selves. And if they don't act that way, then we go back to the participation agreement, which has also been discussed previously. And also, because we are setting the meetings, we are doing things in such a way that we're on our own schedule. The clients are on their schedule. We're not on the court schedule, which I think that means that we can move as fast or as slow as people need to. Because normally for instance, in the divorce arena, sometimes people are on the same page, but a lot of times you have one person that is psychologically behind the other. And so it gives that time for that person to be able to process what is happening. And that does not necessarily happen in litigation. It is moving, it's probably moving too slow for one person and probably too fast for another, potentially. So it's not done willy-nilly. It is all very, very structured, almost more structured sometimes than litigation in some ways. You always know what is happening. The clients always know what is happening. They are always involved. And I believe because they are always involved, it tamps down their level of anxiety that we see a lot in litigation, where they aren't necessarily involved in the process as much because we're having to do things that just have to be done according to the rules of civil procedure in order to keep the momentum in the case going. It may not be something they really want to do, but it may be something we have to do. I don't think I've ever had a client really looking forward to doing a deposition or having to give testimony, but those are things that have to be done in litigation. And with that kind of goes, that sort of follows into the parties control the decision making. They decide what meetings they, how do we, they have a say-so in what we're going to talk about at each meeting. They have a say-so in the agenda. After the meetings, we take the minutes and we send them out to everyone. Like Francis was saying, the parties get to review those. So everybody is always on the same page, or should be, with regards to what occurred in the meetings. It's not one of those things where you have to go back in chambers with the judge and your client sitting, out front, and they don't really know what happened with the judge. And so they're always feeling like they're just not really participating in something that's really affecting their lives, something they're going to have to live with forever. We're not. We're trying to do the best we can for them because we are their advocates. But I think that really, really helps them a lot psychologically. It is a completely confidential process. And in that way, and I know Brian is going to talk about this some with mediation, it is like mediation in that sense, that it is completely confidential. What we say and do in those meetings is not to be discussed. It cannot go forward and be discussed at trial. Also, we call it the sort of, I think, it's like the safe container. It is a safe space where we all have a chance to have very honest dialogue. And something I think that was really strange for me on my first go round is I could speak to Francis's client, or I can speak to Brian's client, and they can speak directly to my client. We normally try to use a round table, and I guess, like King Arthur and the Knights of the Round Table. So everybody is equal. We like to do that. Obviously, we don't always have round tables, but I find that it's very helpful. And individuals get to talk through the options in the meetings of what they would like to do, and why one party's option to do something with the marital residence or the retirement makes the other person feel uncomfortable. And of course, in doing that, in order for that honest dialogue to occur, there does have to be some vulnerability. And there has to be vulnerability not only with the parties, but there has to be vulnerability with the lawyers as well. And that is hard. Let me say that again. That is hard. That is a hard thing to do in making that paradigm shift between being a litigator and acting like all the bullets are just going to bounce off of you and being a collaborative lawyer. So anyway, and also, like Brian was saying, to his point, the coach or the mental health professional in Jefferson County, a lot of times we use what's called a one coach model. It's and different practice groups use different models. Not that we're opposed to a two coach model, but that's just what we've normally been doing. And other practice groups do that too. That mental health professional, if one of the lawyers, like myself, may have a tendency to try to go back to the other paradigm and become very positional rather than interest-based, one of the mental health professionals or the coach may say, Virginia, what's driving this with you right now? Is something happened? Has something triggered you? And you have to have those kind of conversations in those meetings. And it's uncomfortable if you've never done it before, coming from litigation. And also, it involves neutral or non-legal professionals. That's, the financial neutral. Normally in a divorce, for instance, we only have one financial neutral, whereas in a traditional litigated divorce, everybody's going to man up and get their own financial person, which increases the cost. Normally in litigation. So that is something that can keep the cost down. Only maybe having one mental health professional or coach that could potentially lessen the cost, because a lot of these litigated cases, particularly in divorce now, mom's got a counselor, dad's got a counselor, the children have a counselor, and then a lot of times they're paying a fourth party who is going to be some kind of reconciliatory counselor and do all the family counseling. And so there was one question in the chat box, and I think it's appropriate to address that now, because there's one of the bullet points on the screen is that collaborative is fiscally efficient. In the chat box, the question was, isn't collaborative divorce about twice as costly as regular divorce with attorneys for each side, one or two neutrals, and possibly a GAL? In my experience, a GAL is normally an entity that is appointed by the court. And so we don't really have guardian ad litem in collaborative cases. What we do is if we think that there is an issue with the children, we will have a mental health professional and be the children's specialist in the case. If we think that that's something that we all agree to, that the parties agree to, that the lawyers agree to, we discuss that. We discuss people who would be good fits for the children, and we all come to that agreement together as a collective group. It is really like when you're in the hospital and you have the doctors and the nurses and the physical therapist and there's another kind of therapist, but all of those individuals working together to attempt to heal the sick patient. And that's what we do in collaborative. We all work together as a team to try to do that. And that's a huge paradigm shift. But I will say this, and this is to me is the most important thing I can say today to everyone as lawyers. In the collaborative process, other lawyers and the neutrals support you. You do not get that in traditional practice, and it is so beneficial to, I think, your mental and physical health and well-being. And I think it is so beneficial also to your clients, because you're getting support, you're supporting others, and you're supporting your client. It's a much healthier process for everyone, and something that is so emotional and anxiety ridden for these folks that are having to go through it, as well as their children. And to get back to, isn't it more expensive? No, not necessarily. Now, of course, if you have a very slow moving process and you have someone who does not want to align with that participation agreement, and they're going behind that participation agreement constantly, which is constantly having the lawyers have to have meetings and meetings and meetings and having to have a meeting to discuss things that people have done that went outside the participation agreement. Absolutely, that's going to get costly, just like it does in litigation when somebody is not answering their discovery and not doing this and not doing that. And you're having to go back up to court every time to talk to the judge. Quite frankly, and I don't think Frances would mind if I talked about this. She and I had a case one time that had every component of a divorce you could have. We had the kids, we had lots of property, we had a very high functioning professional, and there was a side business too that was, and we did that in 4 months. You can't get all those components in litigation done in 4 months. You just can't do it. And I'm not saying that's always the case, but obviously that, and we had a financial neutral, and we had a mental health professional, and both parties had lawyers. And I don't think it was nearly as costly for them as it would have been if we had spent 2 years in litigation. So no, my short answer to that is no, it is not twice as costly necessarily.
Can I jump in on that question? Because that's one of my favorite questions to answer. And my answer to that question has evolved over time. You know, my initial response before I had 30 collaborative cases was, you know, the sort of pie in the sky idea about collaboration as this panacea and perfect solution that was going to make life beautiful for everybody. And what I have come to realize over time is that the truth is, if you are choosing collaborative only for cost reasons, you have done the wrong thing. Your decision to collaborate or not to collaborate should be driven by the type of process that you want to have. There are going to be times when collaboration is going to cost people more than litigation might have. There are going to be lots of times it will cost less than a protracted litigation. But I think that what I have come to realize is the driver is not the cost. The driver needs to be the party's goals, the party's interests, the party's desire to have a forward-facing process where they have the ability to see everything that's going on and have a role in everything that's going on. And they want to focus on their goals and not on laying blame at one another's doors. So I think that is an answer to the question that probably sounds like it's not an answer to the question, because yeah, sometimes it is more expensive, sometimes it's not. But I think that the thing that I realize is that when people are asking it, they're coming to this table because they think they found a cheaper way, which I think is the wrong motivation to come to this table. I hope that makes sense.
And I want to add one more thing to that as well. The other piece, when it comes to the fiscal efficiency, not everybody is in every meeting. So I can also see where when you think, okay, 2 lawyers, financial neutral, 1 or 2 coaches, that's a bunch of people in every meeting. It's not. And here's one area where lawyers have to put their control freak side aside. And it's shocking, to think that we are control freaks, but we are. And allow the parties to meet with the financial professional without us there. Those meetings may not have everybody. It may just be the parties with the financial neutral. And that financial neutral may not charge the same hourly rate as a lawyer does. The clients will meet individually with the mental health professional or professionals. They may work out a parenting plan that fits their family and then bring it to the lawyers to review. The lawyers may not be part of those meetings and may not have their hands in the mix. So you have the right professionals doing the right work at the right time, and when they're done, they're out. So,
but let's add to that, Brian. Yeah. One of the counterintuitive things that we have discovered through trial and error is that it is often the cheapest process is the one that unfolds with the whole team at the table for every meeting. And why is that? Why is that cost effective?
Oh, that's cost effective. Yeah, go ahead.
Because it completely eliminates all of the one-off communication required to keep everybody on the same page. So right. If everybody is at the table who needs to either know what's going on at the table or participate in what's happening at the table, then efficiently we are doing it all there at one time. And I think most recently we have sort of adopted the strategy that is always going to be our model. We may break off from that from time to time, given whatever's going on, but I think we have discovered that actually is cheaper, keeps us all transparent, keeps us focused in the process, keeps the work at the table and not outside the room, and at the end of the day, costs people less money. So
I think that the key piece to what you said is needs to be there.
Yeah.
And I think that's what it all boils down to. And what I was hoping that I wasn't stating quite as clearly, it's who needs to be there, who's there. We don't want people just sitting around running up hours and running up bills who are not useful for that meeting, because if they're going to get in the way, we don't want them there for that cost-effective reason. And that's the other beauty of minutes. Even if we weren't part of a meeting, if the parties met with the coach to talk about something without the attorneys, everybody on the team gets the minutes. Everybody, and the parties have to sign off on them saying, yes, this is what we talked about. I agree that this is what we agreed to do as our next steps, and everybody sees it and everybody holds everyone accountable. So.
Well, I think, Brian, it's your turn to talk about what's the difference between collaboration and mediation.
Okay, and I'm happy to do that. So collaboration often feels like, for lack of a better analogy, somewhat of a cousin. It is definitely an ADR provision with this, while we're falling under Eileen's umbrella here. There is no neutral third party in collaborative. That's the key difference. There's the transparency, there is the confidentiality, there is the open communication, there is the brainstorming and creative problem solving. But what you don't have is that neutral third party coming between the parties. Some parties need that, and if those parties need that, then collaborative is not for them. Mediation may be, and certainly I think mediation is a much healthier resolution process than a trial for most people. Not for everybody. Some cases just have to be tried. But just as not every case fits mediation, not every case fits litigation, not every case will fit collaboration. We'll get into that in a little bit again. But the mediators not there. You don't have the neutral third party serving as a communication conduit. Communication is direct. Mediators can't give legal advice, but attorneys in collaborative processes do, and we do it in front of our clients, usually jointly. Both parties, both lawyers saying, hey, here's what my read is, here's what Virginia's read is, and this is what experience we've had with the courts on these issues.
And Brian and I have a case ongoing right now where we have had to disagree.
Yeah, we
transparently in front of our clients.
Yeah, and that's and I think it led to very healthy discussion and a very healthy movement forward for the parties. Parties in mediation can feel like they've given up some amount of power either to the mediator or to their attorneys. I know as a mediator, I often will see situations where I'm in a caucus room with a side, and the client, you can tell, is wanting to say something, but the lawyer keeps cutting them off. That was just frustrating as I'll get out for a mediator. But the clients aren't ceding their power to any third party here. Instead of the lawyer standing in front of the parties with potentially a mediator between the lawyer and the other lawyer, your lawyer is next to you, or maybe a little behind you, shoving the client the communication process, and you're not ceding your authority to any third party, whether it's an attorney or a mediator. They're working directly with the attorneys, the mental health professionals, financial professionals, to craft the solution that fits. And so that's one way I think it's also comparable to mediation. In collaborative, you are going to create the agreement that fits those parties, their family, their situation. It's not going to be a cookie cutter outcome because you have the freedom to really get in and dig in and explore what needs to happen to meet whatever fears the clients have. Is fears of stability, fears of financial stability, housing, custody. It's able to be addressed in a much more holistic way than it can be either through, I feel like, either through litigation or mediation. And the other piece being the time constraints of mediation are different. I know as a mediator, if I have people come, they're hiring me for half a day or a full day of mediation in which to settle this case. Collaboratively, we may say, okay, we're going to meet for an hour and a half this Tuesday, and we're going to meet next Tuesday for another hour. And you're doing it in bite-sized chunks that the clients can chew and swallow. So those are the main ways that I see differences. And Virginia and Francis, if either of you have anything to add to that on the differences between mediation and collaboration, please feel free to chime in. If not, we'll discuss when we think collaborative law is appropriate to a case.
Yeah, I don't think I can add. You're the mediation guru, Brian. Thank you for that. I think probably one of the most fundamental questions that people who are new to collaboration ask is, when is it appropriate to collaborate? Who's the appropriate person to collaborate? And I think our experience has taught us that there's not really, we can't draw one clear, distinct picture of that. Initially, it needs to be a process that both parties have chosen. And they need to have chosen it with informed consent. They need to be fully aware of what is going to be required of them. And it does require a lot of parties. Just like there's a paradigm shift for lawyers and mental health professionals and mental and financial professionals practicing in collaboration with one another, the parties have to make a paradigm shift. The world we live in is sort of structured around pointing fingers, laying blame, building cases, fighting wars, bargaining positions. And so, the best suited people to collaboration are those who are really seeking a different way. They, for whatever reason, want to preserve the relationships that they have to the extent that that is possible. But we have certainly collaborated cases where there there were some narcissistic personality disorders. There's been some mental health issues. There's been some alcohol abuse issues. There's been infidelity. There have been lots of hurt feelings. We've had to deal with lots of trust issues. So I think that to the extent that lawyers want to look at it through the filter of, oh, this would only work if the parties are just sort of both easygoing and kumbaya oriented. Well, that's really not true. We've handled some stuff that would have been tough in any context. But I think the beauty of the process is that it is designed to rebalance the power between the parties. Litigation generally is designed to exploit the imbalances that exist between the parties. So that, for example, if one party has all the money, they lawyer up and have the lawyer with big teeth, and they grind the file until the poor person can't do anything further. Collaboration, it's very common for us as the sort of first order of business to decide who's going to pay for the process or how the process will be paid from marital funds. So another thing that that we commonly are able to address are just sort of those power imbalances that exist in the style of communication that the parties have, and the ways that they trip over each other and mishear each other and escalate their conflicts around what their dynamic is. So there's not a simple answer to the question of when is it appropriate, other than to say you need clients who are well informed of all of their options. I guess this is probably a good time to mention that Alabama does have a Uniform Collaborative Law Act. And in the Uniform Collaborative Law Act, we are commanded to be in compliance with that by providing our clients with all of the options that exist for them with regard to resolution of their dispute. So we have to explain what mediation is and what its pros and cons are. We have to talk about kitchen table negotiation or other forms of uncontested divorce. We have to tell them what the issues are around litigation and let them make their own choice. So primarily, I would say it is appropriate for those who make an informed decision to choose the process and to work within the parameters of the participation agreement. Virginia, what do you think about when it's not appropriate?
Well, when it's not appropriate is when I believe what I have seen and what other practitioners have also shared when we talk to each other is when folks are thinking there's individuals out there where they think, okay, the collaborative process, I can manipulate everybody in this process. I'm going to get everybody to work for that. They think it's a process where they're going to somehow be able to be in charge. And we've all dealt with those kind of folks. And let me just tell you, they may think that, this collaborative thing is all kumbaya, but these collaborative lawyers will cut you off in a heartbeat. they'll terminate the process on you in a heartbeat. They're not scared to terminate it on you. And then you're left potentially, let's just say that you everybody kind of gave you a little leadway, a little rope, and tried to bring you back to the participation agreement a few times, and you still are wanting to, essentially that's the not negotiating in good faith. I kind of consider most of the time folks who don't really want to negotiate in good faith are also the same folks who don't want to provide documents and information normally. There's some folks I think that are real busy and they have a hard time. But that's when I would say that, you just they need to be open and honest that I can't get these records together by a week from now. So let's not set a meeting where we're all gonna, have time and money involved here. Like Frances said, and I'm going to jump down to the mental illness or as a chemical addiction, which remains untreated. Those are difficult cases. I think that in the very beginning, those have to be some initial conversations about how to deal with that and how to protect the collaborative group as a whole. from that issue, so that you don't start getting pulled in different directions and people start feeling gaslighted and frustrated, and then the whole process breaks down. It can be dealt with, but it needs to be dealt with initially. You know, something that we've all had, we have had some specialized training in, both as domestic relations lawyers, I know, but also as collaborative practitioners, is the history of the physical or emotional abuse, because that is a severe power imbalance. And how, again, it's not that it can't be done, but there has to be some protective layers and some special considerations. And whoever is the lawyer for potentially the abuser needs to be very, very keen and very, very aware, and the parties all need to have information on certain triggers, so that if that person starts doing those things, the meeting can immediately be terminated. And those also might be some situations where you might get into it and think that everybody's going to be okay, and maybe it's not, but you have to be really, really considerate of those situations. The other thing is when people won't articulate their own interests. I mean, normally the way that the way this has worked for me as a collaborative practitioner is, before a meeting, like, we know we're going to talk about the marital residence and the vacation, whatever, the real property. We're going to talk about that on Friday. Okay. So we sit down with your client, try to generate the interests and options of what they really want. And they're just kind of like, I don't know, or they're wanting you to do it all for them. That's not how this works. Or you get to the meeting and they just won't say anything. And of course I can say it, but, and I might, but at some point they have to start communicating about why that's their interest and why something makes them feel uncomfortable or why they like it. And we have that. But part of our job too, as all the practitioners, is we have to create a safe enough space for them to feel they can do that and feel that they can be a little vulnerable with their spouse. But if they can't do that, and they can't articulate their own interests, and they can't identify things and address things in the meetings, then kind of like, what's the point? So those are some times when I would say that collaborative is not appropriate. As far as serious issues, though, I would say the biggest one to really be careful about is the physical or severe emotional abuse, where you've got a domestic violence survivor and those types of things. I think those are some conversations that really need to be had on the front end, so everybody is aware. So anyway, thank y'all for giving me the opportunity to talk about that.
You definitely need to have a lot of training in collaboration before you take on one of those really hard power imbalance cases, because the dynamics of the parties will be transferred to the team, and everything will go to SHIT fast.
Yes. You don't have the ability to get a restraining order in a hurry in the middle of a collaborative case. I mean, you have to kind of pull the plug on the collaboration, get the person to another attorney if there's a need for a protection from abuse or TRO. It really does, and you better have a really good mental health professional if you're dealing, with the emotional or physical abuse type cases in collaborative, because they really can be exceedingly tricky to navigate. And as to the mental health issues, I think all of us have had cases where we've had to hit the pause button when somebody has kind of gotten from where they were good and able to function and make decisions and participate, where they may be off a little bit, and we've had to hit the pause button, and while the person gets counseling, or the person goes to rehab, or the person gets their medications in check, and then is able to participate again. And it can be very, very, so the key there being remaining untreated. It's not impossible, but these are ones that are going to take, extra patience and extra preparation, and the ability for everybody to be able to recognize, hey, my client may be spiraling here. And not to then say, well, they're just dragging their feet. No, we're going to deal with this and make sure everybody's in a good space before we try to continue with negotiations.
And I think that also underscores the absolute imperative nature of knowing the people with whom you collaborate well, knowing them well in a very personal way, where you can confide to one another your struggles, where you trust one another to call you out. where I mean, there have been times when Brian had to text me in a meeting to tell me my client looked like they were losing their mind because his view of my client was better than my own. You have to have that level of trust that the process is being managed by everyone at the table, that you are not alone to be the hero here, that it is a team process. And you can't do that without trust among professionals. And believe me, that does not compromise your role as an advocate. It does not change the primary hat that you wear as a person who is charged with the obligation of representing your client well. But if they have chosen collaboration, you also have a primary obligation to the process to keep it honest, to keep it true to the participation agreement. And the thing we have learned through Hard Knocks is that if you don't have a trustworthy team, you really should never undertake a collaboration. I think we're done unless we have questions, right?
I just put up the slide about training, where people might want to look if they wanted to get, certainly this does not count as a training, this overview that we're discussing today. But the alternatives that are out there, if you're interested in getting more information, getting actually trained in the collaborative process, good places to look.
Yeah, you could go to the International Academy of Collaborative Professionals website. We have a connection in Birmingham with a training group out of Maryland or Virginia called Collaborative Practice Training Institute. And I know they put on trainings a lot. And I'm curious if COVID has actually inspired them to start doing more virtual training. I know that was something that they had talked about, were kind of resistant to prior to COVID. So that might be a possibility as well. Do we have any questions in the chat box?
We do. We do have a question that says, how many collaborative trained mental health providers and accountants are in the area? And do you usually use the same individual?
Oh boy, that's a loaded question, isn't it?
It's funny because I think some of that goes to what Francis was just saying a minute ago about when you start working with teams. There are, I would love to see more, honestly. I would love to see more mental health professionals and more accountants and financial planners. Some of it is also generated by, the amount of people who know that collaborative is even out there as far as parties and want to participate in collaboration. I think a lot of people who've gotten trained may, not have gotten, as involved in collaborations as some of the core people who do a lot of the work. So you become comfortable working with professionals that okay, my client really will be a good fit with mental health professional A, or mental health professional A is absolutely the worst possible person to work with my client in this case, so who's option B? You become comfortable and familiar with the practice group, and I think we've used that term a few times throughout the presentation about practice groups, or practice groups in other states. There are. I've not seen an updated list, Francis, recently.
We've trained 45 people.
Yeah.
I think at the last big training we did, and that was an interdisciplinary group. The problem is that it's not the kind of work that you go to one training and then you just break out and start doing it and you're off to the races. And that's a huge disappointment to a lot of people for whom that is their expectation. And so I think that the long haulers, that is those of us who have been willing to get extensive training and stick with it and really sell it over a course of years to develop it to the point of actually having work, is a very small number of people. Brian and Virginia and I have a couple of financial people we work with, one of whom does forensic work and the other is a certified financial planner. There's a third financial planner that's a woman that is available to work with us that we have not yet worked with, but that I think would be good. There's a whole group of mental health professionals, psychologists in Vestavia. They were all trained. And then there were a number of other mental health professionals, but the group that we actually use has shrunk down to even smaller than that, to be honest, just because of the trust and the skill required to do it effectively together.
And a lot of people, I think, realize once they get into it that they personally may not be the right fit to do it. I think there's a lot of interest, and there's a lot of, that sounds really good, but they get the training and they try it and they're like, it does not, to do this, you have to be true to yourself in doing it. Either, I tell people it takes the right professionals and the right clients to engage in collaboration. And if it does not fit you, trying to shoehorn it in and say, no, I'm going to make this tool a part of my practice, if it's not something that fits for you, it's not going to work out.
That's right.
We've had a number of professionals who've discovered that, and I think they've been honest about it, saying, no, I like the concept, and if I've got clients who are interested, we'll refer them to you, but it really is not a fit for me in whichever role we're talking about.
Do we have any other questions, Eileen or Virginia?
I am
No?
not, no, I'm not seeing any more questions in the chat box. If individuals want to contact you, how can they find you? Or if they want to ask you?
I'm available. My firm's website is online, nolanbyers.com.
And mine is online as well. I think it's www.bdtlaw.com. I don't know where Virginia went.
I'm right here. I'm going to type my email address and my direct dial at my office in case anybody wants to contact me directly. I do have a website. I don't really remember what the website address is. I think it probably says something like sextonmiller.com, but I'm such a great marketer that I remember these things. So I'm just going to type my info in the chat box in case anybody wants to communicate with me directly.
That's the way we roll. Transparent here.
Well, thank you, panelists. This has been a very enlightening program, and I really appreciate you, Virginia, Brian, and Francis, for taking the time to educate us on the collaborative practice of law. We hope that it will take off more in the future and get more people interested. And as I mentioned before, this is the first of a 4-part series that we'll be offering. So we will be publishing notice of the next webinar on this topic in the near future. You can visit the Alabama Center for Dispute Resolution website, as well as our Facebook page for the announcements. But we also, if you are a member of the dispute resolution section of the State Bar or a registered neutral with the center, we've been posting, sending notice out to those groups, as well as working with the Alabama State Bar and their events calendar to make the public and the lawyers aware of our training. So thank you to everyone who joined us today. I did put a link in the chat box for the SurveyMonkey evaluation. We ask that you please complete your evaluation by March 9th if you're seeking CLE credit. The code was also entered in the chat box, but it is ADR 2021, very original ADR 2021. And so if you'll please do that. Now, I'm not going to promise that the CLE credits will be posted on March 10th, but they will be posted after March 9th. So thank you again for joining us. Thank you, panelists, for a great program. I will let you know that we are sponsoring another webinar on March 18th on the topic of cybersecurity. And so if you are interested in learning more about that, which is a really interesting topic, we invite you to register as well. And this program is being recorded and was recorded, and we hope to have it posted on the center's website, as well as with the Alabama State Bar with their ProLearn, where we will be coordinating with the bar for that. And with that, I don't see any other questions in the chat box. Thank you again, panelists, for a great program, very smoothly presented, and I very much appreciate you all. Any closing comments?
Just thank you for letting us get out here and talk about it. We appreciate it.
You're welcome. Y'all do a great job. Okay, with that, we'll go ahead and end the meeting for everyone, and hope y'all have a good remainder of the afternoon.